Hello, everybody. This is Gary Berger of Berger Law. We're here for our weekly Ask a Lawyer Facebook live show, and I'm coming to you from the great confines of my home today. I've done a bunch of these in a row from my office. It's interesting working in these Corona times with the incidence level skyrocketing now in Missouri, where I live, and in other places around the United States. We had initially, we've opened our office, gone back to a staggered method of working, socially distancing, closing doors, not going in when we're sick. If we think we've been not socially distancing, we stay away or get tested. But with this going up, some people have stayed home, and so I've been going back and forth. I've done a lot of depositions, mediations. I have depositions. I was in Zoom meetings all day yesterday, and I've been in and I have depositions for the rest of the week. One of my great lawyers who works for me, Tyler, was in a deposition all day today. He and I did a lot of work to get ready for that, and I think he did a great job. So with this, what we do in this Ask a Lawyer show is we answer questions that people might have during the. It's harder to get information these days about common legal questions and that kind of stuff. So we ask questions. So I'm going to jump right into some questions that I've been asked, and that are going to also some that are going to come up in our comment section to this. I was asked by a friend of mine, a great local reporter, TV reporter on Fox 2 News, a guy named Chris Hayes, who's an investigative reporter. He's got Emmys, he's got a long history of reporting on great stuff. He asked me to do, and I'm going to get my bow tie right. There we go. All right, perfect. He asked me and ran a segment on going back to school with Corona, which is very timely now. He did a series of stories, and he's got a series of stories on this on the Fox 2 local Fox website. It's very applicable or very hot topic now in my house, with three of my kids going back to school, all at different schools, different levels of schools, college, high school, grade school, different plans in place with the increase, as I mentioned at the beginning. Now more and more Kirkwood, Richmond Heights, Maplewood, all these schools are going to just online now for the first 9 weeks or so. So the pandemic is a changing picture, and it's always always changing. So here's the question that Chris asked me, is that with the changes in athletics for kids, and there's been a lot of news on this week, what is it appropriate for a school to put a waiver in athletics for COVID or Corona? And I spoke about that last week a little bit, but that was on a news segment Friday night. And as I mentioned, you have a right to an education, so they can't have you sign a waiver to go to school, but they can have you sign a waiver to participate in athletics. And that waiver has a provision that you're not going to sue the school if you get Corona from going to practice. And and if you're going in athletics and mingling closely in a non-socially distanced or protected way with a bunch of athletes or against different teams, then you're going to be exposed to that. The thing that I do like about that waiver is that it has the parents' promise, the parents of minors promise to not send their kid to practice or to athletics if they think they might have been exposed, if they think they're symptomatic, if they think any of that. So that was one great thing and great idea that I saw in the waiver. These waivers, it's a part of being in athletics. You always have to sign them, and that's just part of the deal. You remember there's limitations. You due process rights in signing these, substantive and procedural due process rights, and one of the questions is injury or damages suffered by someone reasonably contemplated when you're signing the waiver. And if the answer is yes, the waiver is going to be enforceable. If the answer is no, it's not. Although I will tell you, I have been litigated and also have been a witness to different injuries where waivers were at issue, and they're not going to throw your case out. It's an affirmative defense. The defendant has to come up with the waiver, has to show it, has to prove it. It becomes a summary judgment issue. Sometimes they're enforced, sometimes they're not. Sometimes it may go to the jury. So, does the jury going to think that's fair? So don't think just because you signed a waiver, you shouldn't call a lawyer like me to ask questions about an injury, because it's something we pursue, and then we fight that. These lawsuits, these legal claims always have hurdles to overcome, and that's just one. Let me keep going to some more questions. Rather than meandering too much on one issue, I like to move through questions. I don't have a guest this week. I'll bring in a guest next week. It's just me today. But I did wear a bow tie, unlike last week. And I do still have my same haircut. I was thinking of doing it. The question is, do I break down and go to like a real barber? Or do I just keep doing it myself? We will see. Vamos a ver, as we see as we say down in Mexico. Adam asked me, "Hi Gary, I wondered if a person's own negligent mistake contributed to their injury. Does that preclude them from suing damages or making a claim?" The answer is 1986 Gustafson versus Benda in Missouri. Longer ago than that in Illinois. And the point of that statement and that side of a case, which literally, Adam, I did not look that up before. Or anything like that. So we have comparative fault in every state in the union. We have comparative fault where if you're partly at fault for causing an injury, and that doesn't matter whether it's a car wreck, motorcycle, truck, if it's premises slip and fall. Med mal is not typically involved in comparative, although it could be. Product liability, if you're comparatively at fault, the jury can assess a percentage of fault to you. So let's say the jury in a car crash case with complicated facts thinks you're 10% at fault and the other person's 90% at fault. They also figure the damages, and then you get 90% of those damages. So if your damages are $100, the jury says the damages are $100. Adam's 10% at fault. The defendant's 90% at fault. Then the judge, not the jury, does the math and comes out with a $90 recovery. That's how it works. Now, and there's crazy cases where there's a huge amount of damages and they try it and the jury finds the plaintiff 75% at fault. Now, in Illinois has a law that you have to be, it depends on the number of defendants, but you can't, if you're 95% at fault in Illinois, you can't recover anything. So there's a comparative fault statute that's modified that if you're more than, that if a plaintiff is more than 75% at fault, they cannot recover. So there's an absolute bar. But you got to be, if the plaintiff is mostly at fault, the odds will win in that case. The jury isn't going to think that's fair. So it's kind of in your gut. Brennan asks me, he says, I don't know how to phrase his question. If my wife was sexually assaulted, I think he's laughing because I don't think Brennan has a wife. Probably, I don't know if he even has a girlfriend. Maybe if he shaved and cut his hair a little better, maybe he'd be more, or maybe we didn't have a pandemic. I mean, Lord. But no, Brennan's a great guy. I think the ladies should be chasing him. Very smart, successful guy. So it's a question about sexual assault, and this is a tough topic. So we've handled many sexual assault cases. We've been successful in them. Sexual assault is very difficult for the plaintiff, for our clients, and for the victim. These damages carry on with people for a long time. One of the things we're able to do in cases is work with our clients to try to take their power back, to take their not be a victim, to give strength and overcome it. So one of the things I try to do in these cases is not just try to get a great recovery, and I'm not a therapist or anything, but I know the medicine on it. I know I've represented a number of people in this. I know how it hurts people, and so I try to encourage them to, through the litigation process, to fight back and take their power back and stand up for themselves, and then they feel in control and not a victim, and not is scared to be alone or whatever their fears end up being, to be accosted, to be attacked, to feel unsafe. Very important part of the cases when we take these cases. So the question is usually the male. So assuming it's a woman who's assaulted, as your question hypothesizes, the male doesn't get a right. Don't flatter yourself, Brennan. You don't have a right to the claim. It's the woman's claim. It's her claim, especially if it was before you knew her. Now, you could have a claim if you were with her for a loss of consortium claim. Those, you have to be careful about those claims. But statute of limitations on those claims is, a negligence claim is a 5-year statute of limitations in Missouri, 2 years in Illinois. Different states have different, most states are not less than 2 years for any statute of limitations. So something way back years ago, you would not have that. Now, there are special statutes for repressed memory or people not taking action against certain institutions like the Catholic Church or other big institutions that had a history of systemic abuse to children or other people, where people have repressed memories, and sometimes those statutes have been extended. Now, that was also the negligence statute. The statute for assault or other intentional tort actions is more. So there's a lot of issues that come and go in these cases. Is there insurance coverage for the defendant? Is the defendant work for an entity? Was the assault part of a policy or part of a systemic problem with the entity that did the assault? So there is those are a lot of the issues that are going around in personal injury cases for assault, sexual assault. And yes, Brennan, your last part of your question is yes, it is all. These are always also criminal cases. So and we've had many cases where there's a criminal element, and we navigate the client through the criminal side of it, and then take the civil case. We usually try to resolve the criminal case before the civil case, so that's done, and no one can accuse. So the prosecution gets done right. Remember, the standard of proof is different between criminal and civil. In criminal, it's beyond a reasonable doubt. In civil, it is more likely than not. So, which is very different. So 100% versus 51%. And we talk about this in voir dire when I pick juries in civil cases. We talk about that, making sure that juries aren't going to try to hold us to a higher standard than the law would provide or affords or requires. Because it's a civil case. In a criminal case, someone's liberty at stake. So we have this high standard. In civil cases, we do not. So there are situations also where there's not enough evidence or strong enough evidence for a criminal case, like a 13-year-old assault, as you hypothesize, but there is enough for a civil case. And so, and also sometimes civil statutes are extended or told longer than others. Davey asked me, hi, hello, Davey, how are you? It's good, always good to see you, or to see you virtually. How do eminent domain laws work? If the local government wants to buy your house and to put in a road, can you ask for whatever amount if you want? Is there any way to tell them no and keep your property? So great question. So they can buy your house and put in a road. You don't ask for whatever amount you want. You have a claim against them for the value of your property. You can sue them for that. There's lawyers that specialize in doing that. I practiced with one when the airport was expanding and they were taking all that property. He signed up a lot of those cases and filed, and there was an administrative process to determine it. And if you don't agree with the administrative process, you appeal it and have a right to a civil trial to that. Remember that it's the value of your property. So unfortunately for you, if they're putting a road in a place or they're going to expand an airport or they're going to do something, and everybody knows that the value, one of the things people complain, the value of all that property goes down. So someone who sit there in a nice neighborhood and all of a sudden plans get leaked, then that's a bad deal, because then you're like, oh, great, am I going to invest money in this house? And then a lot of times this takes time. So it's going to be, 3 or 4 years, 7, 8 years while the politicians are figuring this out and fighting and doing this stuff. And then they finally get around and doing the eminent domain action. And by then, everybody who's lived there for those 7, 8, 10 years, whatever it is, they haven't redone their roof. They haven't refinished this. They haven't done the home improvements that people do. So their home values are somewhat declining. And also people who are moving out, no one's moving in because they don't want to move in when they know it's going to be eminent domain away from them. It affects the prices. So there's a whole spiral. There can be a whole spiral. There can be this. It's not typically a one and done. They don't typically, everyone's not picking a piece of property out and doing it. And what you do is you bring it and you ask about value. You can't say no and keep your property. It's one of your questions. You gotta sell it. They're taking it. It's a taking. It's a government taking, and you can't take without compensation, but you can take with compensation. They do. And there's a whole thing about, well, what if it's a constructive taking? What if you can't? What if someone owns the land? This is all for all the environmental laws. What if someone owns land? The government comes in and says there's ground owls, ground owls that live in the ground. You can't develop your property. And you're like, hey, I was going to make this into the biggest casino in the world. I would make $1 billion. Well, this is just prairie land in the middle of nowhere. Are you kidding me? So there can be a dispute on the value of the property in many ways. That's called a partial taking, a restriction on use, because the government also can restrict use. At my house, I am not going to build a casino at my house. I can't, because I have zoning laws for that. So the government can properly restrict use. The question is, does it amount to a taking and rise to that level? There's heavy litigation in this. It's a whole area of law. I'm sorry to get too far afield in this, but you hire an expert, you hire real estate experts to value the property. So let me keep going down in some more questions. Mary Lou asked me, so if your child is in athletics and going to school, how do you know which place your child contracted COVID-19? You're not going to know. It's going to, well, I mean, you may know. It's going to be very difficult, Mary Lou. It's, contact tracing. We talk about it. So when a confirmed case happens, then people go through and say, who were you around that you could have infected? And then who were you around where you could, where you might have gotten it from? And I don't know, in these waivers and these legal issues, it's not as much of an issue about where the infection came from. It's that you have it, you knew it, or you could have known about it, and you're going back and you're not socially distancing and you're infecting others. You don't want to do that. But in terms of finding out where it's from, that is an issue. That's why I heard an NPR story yesterday about suing for these claims. I don't know if that's going to be successful. So let me keep going to another question. Do you think a judge or an attorney's personal opinions or beliefs and their personal connections ever influence the outcome of a case? I know judges are supposed to be impartial, but humans are biased by nature. Yes, they are. So judges, when judges become judges in Illinois, they are elected everywhere. In Missouri, they're elected except in Jackson County, St. Louis City, St. Louis County, and Springfield, where we have the Missouri plan, where a judicial commission suggests 3 names on applications and interviews to the governor, and the governor does interviews and picks one of the 3. But regardless, the point of that is that a judge is also, Maya, to add to your issue, it's not just biases, but judges are very political animals, very political. and very politically savvy. They don't get to become judges by sitting in an office and not talking to anybody. They're out at parties, they're out networking, they're out working for politicians. They usually have good, strong legal careers and histories prior to assuming the bench or getting that appointment. So that is so they're political animals. So they're gonna be sensitive to that. And a judge's personal opinions. I mean, we look just these decisions coming out of the Supreme Court this term in the 2000 U.S. Supreme Court, the 2019-2020 term. There's a bunch of articles going on this week about how the Chief Justice Roberts worked with Gorsuch and other conservative people to get the LGBT employment discrimination decision, or how the politics behind the DACA decision, or some of these other decisions. There's always politics involved in these decisions. Their personal connections, the personal beliefs influence how a judge looks at the law in terms of being conservative or more progressive. Does their personal connections ever influence the outcome of a case? Judges have ethics rules that they're supposed to recuse themselves if they know the litigants. So, or could have the possible appearance of impropriety in terms of being able to rule on a case. So many judges, most judges, 99x whatever percent of them, are going to recuse themselves and not take a case where they know one of the litigants. Now, how close do they know them? I don't know. Judges know a lot of people, and just because they do know someone, I know a lot of judges. I know almost all the judges, and I appear before them, or I've tried cases in front of them. Believe me, they'll rule against me. I have not won every case. So, and a judge will tell you. I mean, they'll listen to you and they'll say, "That's a great argument, Mr. Berger. Motion denied." I literally emailed a judge today who I argued. I had this one emotional. I use him now for mediation cases. A great guy. I'll say his name, Mark Siegel. He's a retired judge. He works as a mediator. I had this one motion one time in front of Judge Siegel where the other side, and I've known Judge Siegel, I've tried cases in front of him. He'll rule against me. I mean, he'll say, "Gary, stop it. You can't go this far." Or I shouldn't bring him out, but there's every judge. They'll say there's lines you can cross. I've made evidentiary rulings. You don't cross that, and then maybe you try to, and they say no, you can't do it. Judges rein you back in according to the rules of evidence. And we're going to have differences of opinions on that. But judges are great too, because they'll also, like a judge is also going to rule against you and not put error in your case. So then when you go in the Court of Appeals, you don't have error, and then you hold on to your verdict if you get a verdict. So there's a lot of issues. You know, it's one that when you try these cases, it's a joke is be careful what you ask for, because if the judge gives you what you want and you put error in your own case, you're going to lose it a year later on appeal, and you don't want to do that. So even though I know a lot of these judges, they're going to rule against me. Judge Siegel, this example, I had this depot where it was an employment case, and they deposed my client for 3 hours, and they didn't even talk about the meat and potatoes of what this case is about. They're just trying to wear my client down. So I ended the deposition, and they said they wanted to depose him for another 8 hours, and I said, that's bogus. You can't make people sit there and just talk to them, wear them down. Hopefully they're tired and they want to get out of that room, and they're going to make admissions in the case because they want to get out of there. So I went and argued it, and it was great. Because I lost. So I go at Judge Siegel, blah, blah, blah. I had this whole argument. I said that. And the other lawyer didn't even have to say anything. He looked at me and says, "Gary, motion denied. Go finish the depot." And I was like, oh, man, I lost it 100%. And I know he knows and respects me, and I know and respect him. So there you go. I'd probably talk too long about that, but that's the reality. So judges are political animals. They know everybody, but they also know their job, and these judges are good at what they do. And they're gonna. I mean, you hear stories about bad judges, sure, in the press, but I mean, all the judges I appear in front of, I mean, most of them they're pros, and they know what they're supposed to do and what they're not supposed to do, and they're going to rule against you. And if they think they might be biased because they're your best friend, they're going to recuse themselves, and they're not going to rule on the case. Given the same incident and injury sustained, would a younger person or an older person get a higher settlement in a severe car accident? Would the younger person get a higher offer because the injuries affect them longer? The answer is probably yes. So let me instead of giving these long-winded answers, let me just move through and yeah. If you have a permanent pain condition, David, um, uh, and if you're 25 and you're going to be in pain for the next 50 years till you're 75, that's different than a 70-year-old person who's going to be in pain for another 10 or 15 years. So yeah, I mean, how long is that painful condition going to be there? And the other thing is that how long are this person going to need medical care? If you're become a paraplegic because of someone's negligence and you're going to live for 50 years, you have your life care plan, the amount of money it's going to take to sustain you and take care of you is massive. It's a huge amount of money. It's different if you're an older person, you suffer the same sad, terrible injury. So yes, short answer, yes. But it also depends on the injuries and whatnot. An older person can be badly injured and warrant a huge recovery. A younger person can be mildly injured and not warrant a huge recovery. If I got in a motorcycle, here's an excellent question from Kelly. Kelly, I like your yellow dress in your picture. Kelly asks, if I got in a motorcycle accident but wasn't wearing a helmet, will insurance still cover me? If it has to go to court, do I even have a leg to stand on? Ooh, that's a great question. So, I think your insurance will still cover you. Remember, if you get in a motorcycle accident, you're suing another party who was negligent and, let's say, blew a stop sign and pulled out in front of you. This happens, on these, every May on Sundays, every year, people are going out on their motorcycles when it becomes nice. You can read about the sad cases of somebody pulling out in front of a motorcycle and killing somebody. It's sad. It's terrible. We've represented these families. So yes, if you're not wearing a helmet, it still will cover you. If in Illinois and I think Missouri, helmets are no longer required. Illinois, they're not required. Many other states. So if they're not required, you're not required. Even a car crash case, if you're not wearing your seatbelt, your recovery under the comparative fault thing that we discussed earlier is only reduced by 1% if you show that someone wasn't wearing a seatbelt. So yeah, and there is causation. You can still recover, but there are causation issues. So the defendant could come in with an expert and say this person sustained a traumatic brain injury, and had they been wearing a helmet, it would have been less, or would not have happened, or it would have been less, and they will challenge the causation of your damages. So whether the defendants caused the injury or whether the lack of a helmet caused the injury. Now, then again, but for the person blowing the stop sign and pulling in front of the motorcycle, that didn't matter whether they had a helmet or not. If they wouldn't have blown the stop sign and gone in front of you, then you would have just flown right by there and you would have had a nice Sunday afternoon drive in May. So there's going to be issues in it, and the defense lawyer is going to have some guts to stand in front of a jury and say, don't give any money to this person because they weren't wearing a helmet. I mean, that's a tough defense to make. You got to be careful. I would be careful doing that. Has hypnotism ever come up in one of your cases? Repressed memories, maybe one, or if anything like that has ever been cited or used. I have had people do hypnosis to address pain conditions and things like that, I think. I've had people use alternative medicine like acupuncture. I've had to have these Chinese medical records translated from different places a couple times, where you have some great old Chinese acupuncture practitioners that do that. But in terms of hypnotism, not in terms of causation or remembering an event, no. Repressed memories, I haven't had that. Arlene, thank you, Arlene. Arlene thanks me for doing this great legal advice. Thank you, Arlene. You get what you pay for, right? Ha ha! Free legal advice. You get what you pay for. Proud to know you and your family, Arlene. I love your pictures on Facebook with all the kids and all your being a grandma stuff. I'm hoping with the pandemic you're back in action, doing all your child care that you do so well. Davey asked me, With client-patient confidentiality, would a lawyer be able to spill the beans on a client if they wanted to, or does it actually prevent them from doing so? Well, this is like in law school, in our first year law school, our law school ethics class. Um, uh, uh, so that's what you ask. So this is it. So you have the law, you have the attorney-client privilege. If a client tells me something, then and I can't divulge it. It's an attorney-client privilege, and I can't tell anybody about it. Can't tell my wife. Can't tell my kids, friends. If I'm subpoenaed to testify, I can't say it. It's an absolute privilege. But what if a client says that they murdered someone yesterday and they know where the body is? So all these good ethics questions don't come into us in a civil case, because civil cases are kind of boring, but people love the murders, right? We love the murder TV shows, the police TV shows. We love the crime dramas. People don't have a lot of shows about being a civil injury lawyer. I mean, there's a few TV shows like A Civil Action and these other movies and stuff with John Travolta, right? So these examples all happen in the criminal cases. So what if a client, two different scenarios, what if a client comes and says, I murdered someone yesterday and I know where the body is buried and I'm not going to tell you and the police are looking for me. Second scenario, I am going to go murder someone tomorrow. I have a plan and an intent to do it. I'm going to go to blah, blah, and I'm going to go do blah, blah crime. So those are two different scenarios. I think the way I remember the ethics rules is that you do not have to and you cannot divulge where they buried the body, but you can and have to and have a duty to tell them that tell the authorities that your client is going to do a future crime if you think it's a material thing and not just, I'm going to kill that guy. When you're like mad at someone, like, I'm going to kill that guy. Right? When you don't really mean it, kind of a phrase or a way of saying something. I'm not saying it's appropriate to say it. I'm saying people do, right? I'm probably have, but so that's the deal. That's the ethics issue. So we get into that, and it's one of these. So we know the questions, and I think different law goes different way, and there would be ethics rules on that. There's lawyers that specialize in ethics law about that. Casey asks me, what are you going to do with the $3 million judgment you won? Will you get that money for the client? Casey, and the next comment is Casey's referring to something we were in the news about, and I see that we put in on the comment section some of these articles about this recent verdict. We were on KMOX last week. I had a great interview with a great host. I really like that guy. He's a lawyer. I've had cases against him. He does a great job hosting. He's a fill-in. He's an Ask a Lawyer guy and fills in that. Brad Young does a great job on KMOX. He's got a voice for radio, man. He called me on the phone. I'm like, man, your voice resonates. You have a brilliant voice. I don't think I got that voice, but no one's really asked me. So KMOX, if you're looking for someone, let me know. All right. Casey, you know what we're going to do? We're going to garnish Pam Hub. So whenever you get a judgment against someone, what you do, if you want to collect, there's a legal procedure called execution and garnishment. You can execute, and I've executed and tried to garnish people various times over my career. We don't just get money from insurance companies. Sometimes we get personal judgments and try to collect against people individually. There are also collection lawyers that specialize in that. So sometimes I do it myself. Sometimes I do it in concert with other lawyers that just do that that's all they do. So for this one, here's what I'm going to do. I'm going to file a garnishment action, a separate action against her. I'm going to serve her in prison, and I'm going to I'm going to seek to collect anything she has, and I'm going to ask her where she might have any money. It's squirreled away. I don't know how she's going to answer me. I don't know what she's going to do. It's going to be interesting. I don't know what protections she has from giving me that information. I don't think she should have any, because the case of Louis Gumpenberger, where I represented the family, Ms. Birch, and the family of his family, that case is over. So, you don't have a right to not answer questions. You can't take the fifth the privilege against self-incrimination if you've already been convicted, because then there's nothing to worry about. You can't do double jeopardy. You can't be convicted twice. She's going to be in prison for that. Now, the interesting thing is she is being investigated. Pam Hupp is being investigated for the murder of Betsy Faria. And from everything I've read, I kind of researched some of this last week, is that's still a pending investigation. So she may take the fifth on something for that reason, but I don't think she can take the fifth on where her assets are. I don't think that has anything to do with the Faria issues. So I don't think she could validly do that. But so we are going to serve. We're going to file and execute. We're going to file a garnishment. I was going to wait a week or so for the dust to settle. We're going to let the dust settle. We're going to file an action. We're going to serve it. We're going to ask her where the money is and see what's going on with that. And so stay tuned. That is still going on. And then we have some, I think I forgot a question from Brennan. Yes, Brennan, take my, shaving advice. You know what? I've had beards many, many times. I don't have one now. It's all good. You look good, Brennan. I was just teasing you a little bit because you can take it. Apiculture. I'm in apiculture. Bees. I'm a beekeeper. Curious what the difference between beeswax and bees honey. So what bees do, and I have it on my phone. Let me see if I can do this. Can I show you guys something that's awesome? Look at what we have this week. This came in today. I want to try to do this. I'm going to put this up in the comment. Look at that. We have new Burger Law face mask that came in today. So if you want a Burger Law face mask, call us or email us. That's Rodney. Look at, you want to talk, hey, Brennan, you want to talk about hair? Look at Rodney's hair. He's got such corona hair, it's crazy. But look at those Burger Law face masks. Sorry, he didn't give me any. Rodney, people ask about permission about using pictures of. Rodney gave me no permission whatsoever to use this picture. Zero. On a public forum. If you want a Burger Law face mask, we'll mail them to you for free. Don't come by it. We don't want to see it. No offense. We'd love to see you. Let's see you by Zoom. Email us, Gary@burgerlaw.com. Email Casey @burgerlaw.com. Email Rodney, Rodney, RODNEY @burgerlaw.com. And make sure we got your address, and we'll mail you a face mask for free, or a couple, as many as you want. We ordered 100 or a couple hundred of these things. So we don't want to order too many. I want to make sure they were too big. They were big enough. I think they are, though. They look pretty good. We'll mail you a face mask. Difference between beeswax and bees honey. So bees honey is the liquid stuff that's in the little bear container that is the honey that preserves forever. So bee wax is the wax in which and around which they do it. So bees makes hexagon, six-sided cells with wax. They make the wax themselves, and that is their honey or honeycomb. And they will build that. They build that up in the spring. I have pictures I can show you. Oh, yeah, I had that's why I was going to my phone. Let's see if you can see that. Yeah. Oh, see, I have these notices. Let me try to get this up. All right. So they make this honeycomb. Here, I'll put this on the show. So this is my bees. This is a picture of queen cells. These are queen cells. The big cells are queen cells. And these, and I'm going to touch this. These bees are going to move. These should move. All right? Yeah. Here, I'll do this. Let me just touch it. You can see these bees move. Isn't that cool? You know, you can do that with your iPhone. If you put a moving picture there, you can, and then you can touch it, and it'll show you. It'll move for you. So it's those hexagons, those holes there are wax, Brennan, and they make these wax hexagons that are huge, and they make thousands of them. They're full, and they put they do a couple of things with those. One is they store honey in those, so they store honey in that. Number two is that's where they also make new bees. So they'll put the queen lays a fertilized egg in there that becomes a larva. And that turns into a bee in about 24 days and then hatches, and it'll come out of there. I have another picture of a bee being born, and they'll make thousands of bees. So the bees are born through that. They also store honey in that. So typically, if you see a stacked up I could show you my hives. They're outside. I was looking. If you stack up hives, the top, if you see a stacked hive, the top boxes are to get the honey, and the lower boxes are where they do the breeding. So the wax is around there, and the bee's honey is the honey that's stored inside it to feed them in the winter. So let me keep going down in my list of questions here. There's some privatized printer, core civic, overtime suit. Yes, Michael, I know about it. So we have reply, motorcycle accident comments. Kelly thanks me for asking my question. You're welcome, Kelly. One more question. What are your thoughts on protecting feelings when working on a case? In your opinion, is it best to be brutal honest with someone or not? Yeah, the short answer is be brutally honest. People don't pay me to be, people hire, and I teach this to other lawyers, or try to teach it to other lawyers too, is you need, clients value being told accurate, clear advice. The sooner the better. I've had many clients tell me, no one would tell me this before. And I don't do it in a mean way, but look, if you have problems in your case, or if there's things that we should do, or recommendations I have, I always have a solution to these things, but let's name the problem and name the solution. It's better to do that than avoiding it. I believe in confronting these things head on. I have a duty to my clients to give them clear, accurate advice. I'm sure there are, I don't want to get into it, but I'm sure there's lawyers that don't do that and are leery of doing it because they want to avoid the confrontation. It's not that I seek confrontation, but if my client has issues to deal with, they want to know about it, and they want to hear what I think about it. And I don't do it to, I don't want to unprotect their feelings, so I want to be conscious of this, because if people have issues or challenges in their case that have to be overcome, it's most of the time it's nothing that they did, it just is what it is. So you don't, it's not something they created and they're not at fault. I'm sure they feel bad. Most of my clients are have significant economic impacts to them, and they're asking me to recover for them and make them whole for them. So they're hurting financially, physically, etc. So however, so I think it's to be honest with someone, but you can also be nice about it. Say, listen, I just want to let you know that you didn't do anything wrong, but such and such is the circumstances of your case. And in my experience, juries, and claims adjusters are going to discount your case because of that. Or you're going to have a hard time recover, or might as well file suit because they ain't going to pay you for it. Or this is something that we're going to have to file suit and litigate it because we're going to have to prove them wrong because such and such happened. We had it today in a deposition. So sometimes in a case, we talk about whether it's your fault or not. We sometimes encounter defendants who we sue that rather than admitting what they did was wrong, they blew a stoplight, they blew a stop sign, they were driving too fast, they built a dangerous product, they didn't make sure there was live electricity in the wall when they hired someone to cut into it. The truck driver turned into a lane. He didn't look careful enough, whatever. I can give you a million examples rather than the defendant coming in and the negligent party just saying, hey, I messed up, didn't intend to, I'm sorry. They have a whole story about why they weren't negligent, why they didn't do anything wrong. I mean, I've had people sliding down on us into another car. I've had people blowing red lights. I've had rear enders. I've had any case you can imagine. I've done this for 29, 28 years. I've had 1,000 cases. I can give you a million different scenarios where you're like, that defendant's totally negligent. They should be responsible for that harm. But you know what? They're not doing it. They're denying it. They don't want to, whether it's their personality or for whatever reason, they want to fight it. They're going to fight it. And the defense lawyers, the law firms, the defense lawyers love it because now they have an insured who, rather than just admitting what they did, is going to fight it down the road. So that gives them a reason to litigate the whole case and fight it forever. So they're going to fight it forever. That's just what they do. And so that just, I'm sitting here, I'm in these depositions going, oh, great. First of all, I'm going to kill you in the depo. I'm going to crucify you. I'm going to make you show to be, I'm going to show you to be absurd and a jerk and not taking responsibility. And that's why we need jury trials. That's why we have trials. When people don't take responsibility, if people took responsibility, the case is settled, be gone. That's why we settle a lot of cases. I keep pushing them around and show them that it's stupid to try a case against me. So we settle a lot of cases, but we try them too. But when you get up in front of a jury, I say, you know what, this defendant, I love it when they don't take responsibility. I mean, I'd rather settle the case earlier for my client, but that's what I can tell the jury. I can look the jury in the eye and say, listen, we're here for a reason. The defendant will not take responsibility. They did this action. They denying that it's wrong. They're going to keep on doing it. They're out on the road driving right now. Today, when we're done with this trial, they're going to drive home and they're going to be behind you. And they're still going to drive like an idiot unless you give a verdict for my client of a lot of money, a substantial amount of money to fully compensate them for their injuries, not 50% compensated, but fully compensate them. Because if you don't give a verdict in that amount, they're going to keep doing it. And it's not punitive damages, but you need to hold them responsible. If they would take responsibility and be responsible, we wouldn't be here. And then juries feel like they're there for a reason. No one wants to be on a jury where they're like, why am I here? This is silly. I mean, we want jurors to spend their time, and they don't get paid anything or nearly anything to get paid their parking fee. And so we value that. And that's part of their, part of being a citizen is to do jury duty, but we want to make sure it's worth it. So that's the answer to my question. That's the answer to your question. Kelly, I'm going to keep going. Are the results of a polygraph, I got going on that one. Are the results of a polygraph or lie detector admissible in court? If not, what purpose do they serve? So I don't honestly, David, that's a great question. I don't know. I mean, in a civil case, no. In a criminal case, I don't think the prosecution can put it in. I think what they do is in a criminal case, the defendant puts on evidence that they passed a polygraph and bring an expert in there. But then if they do that, the defendant's going to open the door and do all that. It's used mostly in the media. I'm reading a book right now. I recommend it, called The Fixers, by a couple guys. There's a local St. Louis connection, but it's about all of our president's, Trump's fixers that he's had in his life. He's had a bunch of fixers, people fixing his problems, doing dastardly deeds for him, secret stuff. Ray Cohen Cohen, Michael Cohen, the lawyer, and all these different fixers. And in all these cases, like when they had the Stormy Daniels and the other Playmate stuff, they all take polygraphs to show that their stories are true. And then the people parade, and then those people parade around polygraphs in the public, not in court. So yes, they could be admissible under certain circumstances. It has to be appropriate. You have to get in its expert testimony. You have to get through the expert qualifications and the gatekeeping devices the court used for that. Rodney says, obviously it's double jeopardy. Yes, you're right. Oh, Rodney, I thought you were talking about double jeopardy with Hupp. Rodney says Tommy Lee Jones and Ashley Judge, Double Jeopardy is his favorite action movie. It's not my favorite action movie. I mean, I think you got to go to Commando. I think you got to go to, I've been watching a lot of Star Wars lately. Commando is such a great movie. And then the first Predator. I guess I'm an old Arnold Schwarzenegger fan. I mean, I hate to say that because he's a Republican governor, but he's from California. So, I mean, a Republican in California is probably a middle-of-the-road Democrat everywhere else. I don't know, right? Uh-oh. I'm going to get in trouble for that. So I think it'd have to be one of those two. Sweet, old school, beat 'em up, do that kind of stuff. That's all that's coming to mind right now. Of course, the John Wick movies. I mean, Keanu Reeves, what an actor. I mean, that guy, why that guy's not on just doing Shakespeare stage stuff every day is beyond me. What a cute model. Rodney likes his picture. I got to do it. We shared Rodney and Casey's emails on the comment section for the reason that we're going to give out a mask to anybody who wants it. Adam asks, and then I'm going to close it down after this. We've been going 50 minutes. With cumulative repetitive use injuries like carpal tunnel, how is liability determined? If I work for company A for 20 years doing the same repetitive tasks and get fired and take the job at company B, is company B 100% liable for my injuries? In a few months into the new job, no, they're not. Company B is not liable. It's company A, and you'd have a 2-year statute for filing that. So you would file that with company A, Adam. Now, I will tell you that the Terminator, I see the Terminator picture. You know, the Terminator was good, but I don't know. And then, you know, the great thing about Predator is that Predator, you know, keeps going through these, Predator 2 with, who was that one guy who was in the Die Hard movies? And then Predator 3. But then the great and brilliant thing is that Predator and the Alien series match, and the Predator versus Alien. So I'm more of a sci-fi person. I've read sci-fi all my life. I've seen all the sci-fi movies. It's kind of like, if anybody's an Isaac Asimov fan, which I am. So it's great when Asimov had the Foundation trilogy, and that's with the second Foundation, Harry Seldon, and then he had all these other Foundation's Edge, all these other Foundation books. He also separately had the Daniel Olivaw books, which is the robot, I, Robot, Caves of Steel, all those books where Daniel Olivaw gets his new positronic brains and lives forever. So those two, and I'm using my hands, you don't see them. So those two series go parallel, but at the end, Asimov, before he dies, brings Daniel Olivaw into the Foundation and joins those series. Brilliant. Even better than Alien and Predator mixing. It's just brilliant when those things combine. At the end, you're like, whoa. Yeah, Will Smith is great. Will Smith is great. Will Smith, Rodney, no love for the king of science fiction action, Will Smith. Yeah, great. Independence Day, great. But Rodney, I think you like him more when he was a rapper back in the day. So I was answering one more question. Oh, sorry, repetitive trauma. Let's get back to this. So cumulative trauma. So a number of years ago, the Missouri legislature made it harder to win cumulative trauma cases and workers' compensation claims. They changed the standard through tort reform, saying that it has to be the prevailing factor. So it's a harder standard. We still take it. We still win them. But Adam, you asked the right question. You literally now, to win it, you got to be in a place for 20 years doing the same repetitive task to make a claim. And then they're so cheap. Work comp is so cheap. I mean, they'll pay for the carpal tunnel release surgeries. And, a lot of times people have them bilaterally in both wrists. They'll pay for the tarsal tunnel, the carpal tunnel release. They'll pay for the surgeries. But then you're not going to get that much money at the end anyway. So, but have the release surgeries, get comp to pay for it. Come to us. We'll try to settle your claim for your lump sum disability settlement at the end of the case. That's true, Rodney. He's a DJ. I'm a rapper. It's a classic. True. That's true. He's a great rapper. I was listening to that the other day. My kids thought I was crazy. All right, everybody, thanks for listening to me for an hour if you have, or for 5 minutes if you have, whatever it is. Remember that we always answer questions for free at Burger Law. Email me at gary@burgerlaw.com. Email Rodney or Casey or Tyler or Genevieve. Go to our website. You'll figure out all the great people we have. Everybody here working for our clients. Happy to do it. Happy to raise all ships. Not shifts. Ships. Raise all ships with our advice. Help everybody out as much as we can to give accurate, live, true, cut to the nut, give perfectly accurate legal advice. That's what we're trying to do here. Hey, everybody have a great week. This is it's the craziest summer, the summer of 2020. We're going to be into August by the time we do this next one. If we end up boring you with these shows, email me and tell me to stop. Otherwise, I'm going to keep going. Everybody have a great week.